Hi everyone, my name is Nina Holatova and I am a lawyer and program coordinator at the Community Legal Education Association, or CLEA, in Winnipeg, Manitoba. CLEA is a not-for-profit organization and we offer legal education, information, and other resources across the province. Today's presentation is going to be part 2 of 3 in a series of presentations about family law in Manitoba, and today we will be discussing children, parenting arrangements, and child support. The contents of today's presentation are for general information only and do not constitute legal advice. If you do require legal information about your specific situation and you do not have a lawyer, you can contact our law phone-in program for free legal information. In a family law matter, if there are issues that concern children, such as parenting arrangements, child support, and even guardianship, the paramount consideration for the court is going to be the best interests of the child. In Manitoba, we have the Family Law Act, which is a provincial piece of legislation governing common law separations. The Family Law Act provides a list of criteria that the court would consider when determining what is in the best interests of the child. So if you are not married and you're separating from your common law partner, this is the piece of legislation that would apply. We also have the Divorce Act, which is a federal piece of legislation, which also has a list of factors for the best interests of the child, the same as the Family Law Act, and this is for individuals who are married and are seeking a divorce. There has been somewhat of a shift towards shared care in recent years. Some people think that this automatically means a 50-50 split in parenting time, but that's not necessarily the case. The legislation tells us that a child should have as much time with each spouse as is consistent with the best interests of the child. So this could very well be a 50-50 split if both parents are good, active parents who are interested in being involved in their child's life. However, a 50-50 split may not be in the best interests of the child in some cases. For example, if one parent is struggling with addiction, a 50-50 split may not be appropriate. In such cases, supervised time with the child for a few hours every week may be more appropriate, depending on the individual situation. One more thing I want to touch on here is that there has been a recent shift in the language used when talking about parenting responsibilities. A lot of people are used to hearing the words custody and access, but there have been recent amendments to both federal and provincial legislation which have introduced changes in terminology. So instead of custody, care and control, and access, we now use the terms parenting time, decision-making responsibility, and contact. So the court here would consider a number of things when determining what is in the best interests of the child. They would look at the child's needs given their age and stage of development, such as the child's need for stability and the nature and strength of the child's relationship with each parent, their siblings, grandparents, and any other significant individuals in the child's life, each parent's willingness to support the child's relationship with the other parent, the history of care provided to the child's views and preferences taking into account their age and level of maturity, also the child's cultural, linguistic, religious, and spiritual upbringing and heritage, including Indigenous upbringing and heritage. The court would also consider any plans for the child's care, the ability and willingness of each person to care for and meet the needs of the child, the ability and willingness of each person to communicate and cooperate, in particular with one another on matters that affect the child, any family violence and its impact on the parent's abilities to care for and meet the needs of the child, the appropriateness of making an order that would require someone to cooperate on issues affecting the child, and also any civil or criminal proceedings, orders, conditions, or measures that are relevant to the safety, security, and well-being of the child. So, for example, relevant criminal proceedings or child protection proceedings. Now, let's turn our attention to parenting responsibilities. When talking about parenting responsibilities, we are really looking at two different things. The first is parenting time. Which parent has the child in their care? This doesn't necessarily mean that the child is physically with the parent the entire time. So for example, if a child is at school or at a friend's house, they are still considered to be in the care of one parent or the other. The second aspect is decision-making responsibility, or which parent is making major decisions affecting the child if the parties cannot agree. And when I say major decisions, I mean medical, religious, and educational decisions. So, what kind of medical treatment does the child receive? What church do they go to? And so on. For day-to-day decisions affecting the child, that's left up to the parent who has parenting time at any given moment. That would be things like what the child eats, what they wear, if they go to a friend's house, what activities they do, and so on. If that decision-making responsibility will be shared between the parents so that major decisions will have to be made jointly, then parents will have to consult one another on those major decisions, even if they are separated or divorced, and they will have to agree on those decisions before moving forward. If they can't come to an agreement, then unfortunately they may have to take other steps like going to mediation or arbitration, or even referring the matter back to court. In some situations, one parent may have the final say when it comes to these major decisions affecting the children, and they may or may not have to consult with the other parent or to inform the other parent of what's going on, but ultimately those major decisions are going to be up to them to decide. However, this is certainly not the default, and it all depends on how any given court order or separation agreement is set up. Now, moving on to parenting time, you can have anything from a 50-50 split to an arrangement where one parent has 100% parenting time. If parenting time is shared more or less equally, with each parent having the child or children at least 40% of the time, then there are going to be some implications for child support, which I'll talk a little bit more about in the later slides. In situations where that parenting time is shared equally, there are a variety of schedules that can be set up. So, for example, you can have a schedule that's 1 week on, 1 week off, where the child goes back and forth every week, and this is maybe a little bit more common for older children or teenagers. For younger children, it might be more common to see a 2-2-3 schedule where the child is with parent A for 2 days, then parent B for 2 days, then back to parent A for 3 days, and then it would switch. You can also do something similar, but on a 2-2-5 schedule. But again, this is really going to be about what is in the best interest of the children, which can vary a lot depending on the family situation. If parents cannot agree on parenting arrangements, they may have to go to court to have the matter resolved. However, in Manitoba, we have a triage system in our court, and this means that parties have to complete certain prerequisites, showing that they have tried to resolve matters outside of court before they can actually proceed to court and have their matter heard by a judge. Some of these prerequisites include completing the For the Sake of the Children program, which is a free online program. And even if you're not going to proceed to court with your matter, or you're not sure yet if you're going to have to go to court, it's still a good idea for parents to complete this program because it does provide a lot of valuable information for parents about the separation process and also what they can do to minimize the impact of that on their children. Parenting plans are also going to have to be filed, so each parent will set out what they think should happen with parenting time and decision-making responsibility, usually setting out a proposed parenting schedule and explaining to the court why they think this is in the best interest of the child. However, once those parenting plans are filed, they're not necessarily set in stone. The purpose of these plans is really to give the court a sense of what each party is seeking, where the disagreement might be, and whether there is any middle ground that can reasonably be reached. Of course, you want to make sure that you file a parenting plan that is reasonable and that shows that you've given some serious thought as to what is going to be best for the children. So, for example, if a parent is out of the province for work for 3 weeks out of the month, but they are seeking a 50-50 split in parenting time, that's going to be a bit of a tough sell to the court if they've never been able to demonstrate that a schedule like that would actually be workable. Is your job going to accommodate that? If not, are you going to quit your job and find other employment to make that possible? Basically, can you prove to the court that this is actually going to be a reasonable and realistic plan? Then we have assessments, which can be conducted either privately for a fee or for free through the Family Resolution Service of Manitoba. although generally you do need a court order to be able to get a free assessment through them. Once the assessment is conducted, you will receive a report which provides recommendations to the court regarding the best interests of the child. The assessor will usually do a home visit, they will interview each parent, and if a child is 12 years of age or older, they may also talk to the child and take their wishes into consideration in their report. Although assessments can be helpful, they are not mandatory. It's really just one piece of evidence that the court will consider, and it's not necessarily determinative. So just because the assessment is strongly in favor of one parent or the other, it doesn't mean that this is going to be the same conclusion that the court will make once they consider all of the evidence in totality. Now, let's talk about child support. Parents have a duty to support their children, and in Canada, child support is really seen as something that is the right of the child. Parents cannot opt out of child support. Sometimes you will see parents trying to make a deal, saying, maybe if you give me full parenting time, then I won't go after you for child support, or if I can keep the house or another piece of property, then I won't ask for child support. And the court really tends not to like this. Child support will generally be ordered, and of course, parties can choose not to enforce the payments, but then the person who is supposed to be paying the support runs the risk that even years down the line, that child support could potentially be enforced. And once you're in arrears, once you owe that child support, it can be very, very hard to catch up on those payments, so do keep that in mind. There is a somewhat new case that came out of Saskatchewan where the court made a different decision, and they actually enforced a separation agreement where a couple had contracted out of child support, but that is not really a binding decision here in Manitoba, and really only time will tell if other courts follow suit on this. So for the time being, it is definitely risky to try to contract out of child support. The obligation to pay child support also doesn't necessarily only apply to the child's biological or adoptive parents. If someone stands in the place of a parent to a child, meaning they took on a parental role where they assumed the responsibilities and duties that are typically associated with being a parent, even if they don't legally have parental status, they may have to pay child support. This can include a step-parent or a common law partner who acted as a parent, but it may also extend to other situations. As for tax implications, child support is not taxable as income in the hands of the recipient, and it is not tax deductible for the payor. And this is different from spousal support, which does have some different tax implications. A lot of people also ask when child support terminates or ends. Sometimes a court order or a separation agreement will specify exactly when child support will end, but sometimes it doesn't. If it doesn't, child support may end at the age of 18 or whenever the child graduates from high school, generally, whichever comes later. However, it can also continue beyond age 18 if the child continues to live with their parents and continues to be a dependent. This can be because they have an illness or disability, or more commonly because they are continuing on to post-secondary education like university or college or a trades program, for example. Now, there are some limits to this. You can't just have a child who goes to university for their entire life and continues to collect child support for them indefinitely. The limit is generally around age 21 or upon completion of the child's first post-secondary degree. However, there are exceptions to this as well, and there are certain situations where child support may go well beyond this. As well, the child's enrollment in the post-secondary institution must be full-time, and usually that is defined by the institution that they are attending. Next, I'm going to talk about how we can actually calculate child support. Child support is calculated based on income, number of children, and how parenting time is shared. We have something called the child support guidelines and the child support tables. The tables are literally a chart where you can look up the exact predetermined amount of child support based on your income and the number of children. When it comes to determining someone's income, it can be pretty straightforward if they are working in the traditional sense, where they are an employee for someone else and they earn regular employment income and get a T4 at the end of the year, and so on. In this case, all you have to do is look at their tax return, or more commonly, their notice of assessment from the previous year. You would look at their line 150, total income, and that's the number that you would use for the purposes of calculating child support. However, there are some circumstances where this may not be sufficient, and in such cases, a different income may be imputed. This can happen where someone has multiple sources of income, where they are self-employed or they run their own business, where they are unemployed or underemployed, or if they are otherwise earning less than their potential or capacity. So sometimes you might hear of people threatening to quit their jobs so that they don't have to pay child support, and this is really what we are trying to avoid with this possibility of imputing an income. So if someone is unemployed but they are able to work, then the court may impute a higher income, maybe at a minimum wage level at the very least, and the person will then have to pay child support as if they were earning that income. The court may also look at other factors like the individual's education, their work experience, qualifications, available job opportunities, and previous income history. So the imputed amount is typically what the person could reasonably earn given their qualifications and current job market conditions. As I said, imputing income can also apply to self-employed individuals in certain situations. When someone is self-employed, they have a lot more control over their income and how they pay themselves compared to people who have a fixed salary or wages from an employer. There are also certain tax deductions that may be available to them as a self-employed individual. Now, this doesn't necessarily mean that they're doing anything wrong or sneaky or illegal. These might very well be legitimate deductions that are available to them. However, the court recognizes in these situations that the income amount on someone's tax return may not necessarily reflect their actual earnings. Of course, if the person is doing something to intentionally hide their income to avoid paying support, that's a completely different story. In that case, in addition to imputing a higher income, the court may also impose additional penalties. The child support tables only go up to $150,000 though, so if the paying parent's income is higher than that, the child support guidelines may not apply, or there may also be an additional calculation that has to be done. As well, for a paying parent with an income of less than $12,000, no child support will be ordered. The court must follow the child support guidelines unless there is an exception, which is very, very rare, and I will talk about these exceptions in a little bit more detail later on in this presentation. First, I'd like to go over parenting time and how that affects child support calculations. So if one parent has more than 60% parenting time, then they will be entitled to the full table amount of child support. It doesn't matter if they have the child 61% of the time or 100% of the time, that amount will be the same. Again, in this case, the child support amount is going to be calculated based only on the paying parent's income and the number of children. For the parent who would be receiving the child support, their income amount is irrelevant. So you could have a situation where dad makes $100,000 a year and mom makes $20,000 a year. And if dad has more than 60% parenting time, then the mom will have to pay child support based on her $20,000 income. Since the amount of child support is scaled to the paying parent's income, it really shouldn't be something that will cause them financial hardship. If that parenting time is shared more or less equally, meaning that each parent has the child at least 40% of the time, so that would be between a 40-60 and 50-50 split, then the calculation changes a little bit. In this situation, both parents' incomes are relevant. What you would do is calculate what each parent would owe to the other based on what the child support tables say in accordance with income and number of children, and then you would subtract the two amounts, and the result you would get is that the parent with the higher income ends up paying a reduced amount of child support to the parent with the lower income. So if the child support guidelines say that parent A should be paying $800 a month in child support and parent B should be paying $500 a month in child support, the difference is $300. So the parent with the higher income would only pay that $300 per month. There are some critiques when it comes to this child support system. Sometimes you might see a parent who previously had no interest in being involved with their children suddenly pursuing equal parenting time just to try to reduce their child support obligation. And in particular, let's consider an example where, let's say, the mom is earning $100,000 a year and the dad is earning $50,000 a year. If the mom has primary parenting time, then she would be entitled to child support based on the dad's $50,000 income. However, if that parenting time is shared, then she will actually have to pay child support to the dad based on that set-off amount, and that might very well be a significant difference. Ultimately, this isn't something that's extremely common, but it's not unheard of, and it is a critique of the child support system that we have, so it's just something to be aware of. Okay, next, let's talk about some of those exceptions to the child support guidelines. So there are situations where the court may actually award a child support amount different from what the guidelines and tables set out. So I had mentioned that if you have a child over the age of 18, child support may continue if, for example, they are in university full-time. However, let's say that the child is working part-time during the school year or maybe even full-time during the summer, and they are earning a little bit of their own money and maybe paying for some of their own expenses or even contributing to the costs of their schooling. In this case, the court may order a reduced amount of child support based on that. Also, I mentioned that somebody who stands in the place of a parent to a child may have to pay child support as well. So this means that there might potentially be two sources of child support, one from the biological or adoptive parent maybe, and one from the step parent or someone else who has stood in the place of a parent. In this case, again, the court may allow for a reduction in child support. Lastly, the court will consider undue hardship. Keep in mind that this is something that is often argued and brought up in court, but people are very rarely successful with this claim. It is quite rare that the court would actually make a finding of undue hardship, and it is really only something that happens in exceptional circumstances. So there are a few different things that might contribute to a finding of undue hardship. Firstly, the court will look at the income and the household size of both families. So for example, if I have a child support obligation from a previous relationship, but I get remarried and I have a few more children with my new partner, then it's possible that the previous child support amount may be too much for me to pay, such that it would constitute a financial hardship, considering that I have a new family that I have to financially support. Similarly, the court will consider other existing child support obligations. So if I'm already paying child support for children from a previous relationship, I then go on to have more children, and my new partner and I then separate, there may be a situation where I may have to pay the full table amount of child support twice for two different sets of children. If this would create a financial hardship, then a reduction may also be appropriate. Another factor that may be taken into account is unusual family debt responsibility. So if my ex-spouse and I had a lot of debt together, and for some reason I've taken on a lot of that debt on myself post-separation, and those debt payments are so high that paying the full table amount of child support as well would constitute a financial hardship, that might be another reason for child support to be ordered at a reduced amount. Lastly, we have unusual costs of parenting time. So if someone maybe lives out of province and they have to spend significant money to travel to see their child regularly, this is another factor that the court may take into account. Next, let's move on to Section 7 expenses, also known as special and extraordinary expenses. This refers to costs that are above and beyond sort of the regular basic needs of the child. So things like daycare, medical expenses over $100, educational expenses like tuition, and extracurricular activities are commonly considered Section 7 expenses. If parties agree on these expenses, then it's pretty straightforward. Each party would just cover a portion of the net cost of the expense in proportion to their income. So if one parent makes $30,000 a year and the other parent makes $70,000 a year, then they would split the expense 30% and 70% respectively. Now, I say net cost because sometimes we have things like childcare subsidies, insurance for medical expenses, scholarships, and so on that might cover a portion of the expenses. So only the part that is actually paid out of pocket, aka the net cost, will be shared. If parties do not agree on Section 7 expenses, then parties may have to take other steps to make that determination. The first consideration here should be whether it's even worth it to fight over. For example, if it's $100 per month in piano lessons that's in dispute, it's probably not going to be worth it to litigate something like this. In cases where parties do decide to take further steps, the court will have to determine whether those expenses are reasonable, necessary, and in the child's best interests. The court will consider factors such as the financial means of each parent, the history of past expenses, whether there are any available alternatives that are free or maybe at a reduced cost, the impact on the child's well-being, and even something like the child's natural talent may be relevant. So for example, if you have a child who is really great at hockey, maybe he's on track to be in the NHL someday, it might be reasonable to put him in a really expensive hockey program. But on the other hand, if you have a kid who's pretty average at hockey, maybe just plays for fun, it may not be reasonable to put them in that same program. So again, it all depends on the individual child and the family situation. Okay, so now that child support has been ordered, how do we actually enforce it? Once you have that court order or separation agreement, how do you get the other person to pay? So generally, child support and spousal support as well actually are enforced through the Manitoba Maintenance Enforcement Program, otherwise known as MEP or MEP. It is possible to opt out of maintenance enforcement if both parties agree, but it is usually a very bad idea to do that. If you register through MEP, then they take care of processing all of the payments and they act sort of like a middleman between the payor and the recipient. If payments are late or if payments are not made at all, they can enforce late payment fees and penalties, and they can even take further action to bring accounts up to date, including issuing a support deduction notice, garnishing wages, suspending a driver's license. And if the person still continues to not pay support and they don't have a good reason for missing payments, then MEP will take them to court, and the person who is in arrears may even face jail time. On the other hand, if payments are not registered through MEP, then you might have a much harder time enforcing payments if the person stops paying support. You are then going to have to be the one to try to seek enforcement measures yourself, and that might include going back to court, which can be very time-consuming and costly. Support can be varied or changed if there is a change in circumstances, and that would usually be either a change in parenting time or a change in income. Both parties have a duty to disclose changes in income, and this is usually done on an annual basis, and child support has to be adjusted accordingly. It's not uncommon for parties to include either in a court order or in a separation agreement a clause that makes it mandatory to exchange financial documents every year to ensure that child support is being updated according to income. You can also ask the court to vary other parts of a court order, like parenting arrangements, but you must show that there has been a material change in circumstances. The Child Support Service, which is under the umbrella of the Family Resolution Service, can now also make initial determinations of child support and get a court order without the need for you to go to court. Further, they can recalculate child support regularly after an order has been granted or after a separation agreement has been entered into. Generally, they only do the recalculations for the table amount, but they will do it under certain circumstances for Section 7 expenses as well. It's important to know that child support can be ordered retroactively, and there is a general 3-year limitation, meaning that you might be ordered to pay child support for the last 3 years, in addition to child support payments going forward. For this reason, I would always encourage people to make child support arrangements as soon as possible after separation to avoid accumulating arrears before child support has even been ordered. However, if someone has been doing something to intentionally avoid paying child support, or if they have intentionally been hiding their income to avoid paying a higher amount, the court can and will order retroactive child support even beyond that 3-year limitation. And this brings us to our last slide here. So here we have the Winnipeg number as well as the toll-free number for the Community Legal Education Association, Law Phone-In, and Lawyer Referral Program. I'm also leaving our email address on the screen as well as our website, which has a lot of great resources, information, publications, and videos. And lastly, we have these two government websites. We have the Family Law website, which includes information about the Family Resolution Service, and the Manitoba Courts website, which provides information about forms, procedure, and other court information. Thank you so much for joining us today. If you do have any questions, please feel free to reach out, and we will see you in part 3.